Welcome to Rebel Chaser. My name is Gail, and I've got several clips for you tonight. The first one is from Judge Mercer in Florida. He's got a guy who just can't stop contacting his victim. The next one is with Judge Braley in Michigan. And then I've got a couple from Kansas, Judge Crum in Kansas, and they're actually a couple. They're partners in crime. And then I've got two from Judge Bowie in Michigan, and also another guy who just can't stop contacting his victim. And then I've got several from Judge Fleischer in Texas. I know you guys all love him. I recorded these on Tuesday. Hopefully you haven't seen them all, but I hope you enjoy them either way. Let's go.
Next, we have Timothy Gibbs. Mr. Gibbs, good morning. Mr. Gibbs, you got a couple of issues. The first thing is you're held 10 days on a violation of state probation to see if the state probation that requested a warrant and what the circuit judge did with it. I looked at the computer file this morning and there is a no bond warrant signed. So what we're going to do is go ahead and get you arraigned on that violation of state probation case. And then I'm going to ask the sheriff's department, Sergeant, if you can get them to serve that warrant today, that'd be great. So even though you haven't been served with the warrant, it's in the system. I see it was signed several days ago by Judge Garcia. It just hasn't actually gotten served yet. We're going to go ahead and first appear you on it because I want to get you a lawyer appointed if you want one. Mr. Gibbs, do you want to have an attorney appointed to represent you in the VOP?
Yeah.
I'm going to appoint the public defender's officer to represent you, Mr. Gibbs. Listen to Mr. McDaniel, please.
Your Honor, we're going to enter plea of not guilty. He has to set this in the May 14th pretrial docket, and I've already advised Mr. Guy Green to come by and visit him prior to that hearing.
Thank you. Ms. Bremer, anything from the state?
Not on the issue of his probation.
Thank you. So, Mr. Gibbs, the public defender's officer will come out to see you before the court date. The second issue is we received information from the jail yesterday that you have allegedly had contact with the alleged victim. Two problems with that. Number one is you ordered a condition no contact when you originally first appeared. The second problem is that may result in charges of tampering with a witness. The email I forwarded Mr. McDaniel and Ms. Bremer this morning and Ms. Jeffcoat says there were 30, he's contacted her 30 or communicated with her 32 separate times, including telling her instructions on go and drop the charges, tell them I didn't hit you, stuff like that. State want to be heard on that issue?
Yes, Your Honor. The state would request that his bond be revoked in the case number 24-235 CF. We also request that his phone privileges be limited to issues related to his defense with his defense attorney.
All right, Mr. McDaniel, you want to be heard on that request?
Your Honor, that's a extraordinary, I guess, request. I mean, I would ask the court that's a jail issue as far as as far as phone calls going out that obviously he should not be. They shouldn't allow him to have phone numbers, and maybe the jail has the ability to restrict phone numbers where he's maybe calling her, but to restrict all communication, I think, is an extraordinary request. And I understand that he's broke the bond, by having contact, and I don't disagree with any of that. But the second request, I think, is kind of extreme, though, Your Honor.
They actually approved her numbers.
Yeah, I don't know that you can. The problem is with that system, which I didn't approve. I don't like it. That the county has. With that system, he can put somebody's number in there, and if she's at their house, he can call that person, and all they do is put her on the phone. So what I'm going to do is this. I'm going to revoke your bond, Mr. Gibbs. You now have no bond in that case, and I'm stopping all conversations you can have other than with your attorney, period. So no phone contact at all. He can communicate with his attorney unlimited. His attorney can see him at the courthouse, see him in person. If the attorney wants to set it up by phone, I don't have a problem doing that, but it needs to be set up by the attorney. So, Corporal, he needs no phone access at all unless it's his attorney calling him, because I've got to do what I can to keep him away from this alleged victim, certainly. I'm going to ask the state attorney's office to take a look at those phone calls. If you determine there should be criminal charges filed, you certainly know how to do that if he has tampered with a witness, as has been alleged. Mr. Gibbs, you've got no phone contact, you've got no bond, and you'll see Judge Garcia at your next court date. Do you have any questions?
I do. Last time I was here, I misspoke in requesting a speedy trial. I'm actually under Florida Rules of Criminal Procedure 3.191, demanding for a speedy trial. which if you're familiar with, kind of changes the timing of everything, or at least it's supposed to.
It doesn't, because you've got an attorney appointed to represent you. You just asked for one. Therefore, your pro se pleadings don't have any bearing. You haven't even, the state hasn't even charged you yet, Mr. Gibbs. They have 40 days to charge you. Then once you're charged, then we can figure out your speedy trial rights. You certainly may have the right to represent yourself if you choose to do that. You haven't even been charged. We're way ahead of speedy trial, just like I told you last time. We'll see you at your next court date, sir.
Okay.
Now calling case number 24T00150. This is Ypsilanti Township versus Donovan Lee Lawrence. Mr. Lawrence, put your jacket back on. Appearances for the record, please.
Thank you. Assistant Public Defender Sonia Shannon on behalf of Mr. Donovan Lawrence.
Mr. Lawrence, state your name for the record.
Donovan Lawrence.
Today is the date and time set for an arraignment in this matter. Mr. Lawrence,
Yes.
you were before me on Monday.
Yes, ma'am.
And when you were before me on Monday, I set a bond with conditions that included no alcohol and also no assaultive behavior. What I have is an allegation of both alcohol use and assaultive behavior.
This should only be alcohol use. That's the only thing that they got me for. I was sleeping under a bush. And
Mr. Lawrence, I'll advise you not to talk.
okay.
Regardless, alcohol use
Right.
was not to occur. That was one of the bond conditions. For Monday, today is Friday.
Right.
Did you hear me on Monday?
Yes and no. It's kind of a whirlwind, to be honest. I mean,
Okay, you can stop.
yes.
Attorney
Yes.
Chenault, do you wish to address bond?
Yes, thank you. I did have the opportunity to speak with my client. I don't believe he's a flight risk at this point, Your Honor. He did express that he will be able to abide by all the bond conditions going forward after today. So therefore, we're going to ask for a personal bond at this time.
Mr. Lawrence, I am setting your bond violation hearing and pretrial on May 20th, 2024. That will be at 9 a.m. over Zoom before Judge Washington. All of the prior conditions that I went over on Monday are still in place. They have not changed. They are still in the Law Enforcement Information Network, and they will remain in the Law Enforcement Information Network. I am adding a couple more conditions. Prior to your release, you are to be fitted with a scram tether. And within 24 hours of your release, you are to report to community corrections for drug and alcohol testing. You will need $12 and a photo ID.
Okay.
Okay.
Quick question. Is that tether just for the alcohol and the drugs?
It's an alcohol tether, yes.
Okay, just asking.
Okay.
That's perfectly fine.
I'm so glad to hear that. I am setting a $10,000 personal recognizance bond. So if you violate any of these conditions, your bond will start at $10,000. And please believe that if I'm arraigning you again next week, the conditions are not going to get any better than they are right now.
Okay.
So if you fail to report to community corrections within 24 hours of your release, or if you are using alcohol or drugs, you can expect to be picked up on a bench warrant again.
Okay.
Okay.
Sounds good.
Attorney Chenault, do you have anything else?
Nothing further. Thank you.
Okay. Thank you. Then this hearing is concluded, and Mr. Lawrence, you are free to stand up and tell the jail that you are finished.
Thank you.
Right,
This
are
is,
you're Weldon Bar 2?
yes, sir.
All right, there are two cases set at this time. State of Kansas versus Weldon, Eugene Bar 2, 24 MR 61 and 24 CR 212. I'm going to go over the CR 212 case first. Do you have a copy of your charges yet, Mr. Bar 2?
No, sir.
All right. There are 4 counts, all alleged to have occurred on May 4th or May 1st, 2024 in Butler County, Kansas. Count 1, you're charged with unlawful possession of methamphetamine. That is a level 5 drug felony. Count 2, you're charged with interference with law enforcement. That's a level 9 non-person felony. Count 3, you're charged with possession of paraphernalia for use. The paraphernalia item being a plastic bag, I'm assuming used to store the methamphetamine. That's a Class B non-person misdemeanor. Count 4, you're charged with unlawfully obtaining or exerting control over a white Dodge 1500 with the intent to permanently deprive the owner, Ernest Tescom, of the use and possession of that vehicle. The vehicle having a value of at least 1,500, but less than 25,000. That's theft, a level 9 non-person felony. Since you've got some felony charges here, you won't be asked to enter a plea today. Your case has been assigned to Judge Ricky. Your next court date will be in front of him on June 17th at 2:30 p.m. by Zoom, June 17th at 2:30. Can you afford to hire an attorney to represent you on these charges?
No,
Do you wish to apply for a court-appointed attorney?
not to represent myself.
All right. Do you understand that if you can't afford to hire an attorney, one would be appointed to represent you?
Yes, sir, I understand that. I also understand that every court-appointed attorney I've had has been shit. I would rather represent myself.
Okay. Well, you certainly have that right. But I've told you your right to have an attorney. You wish to waive that right. Do you all have a waiver of counsel form there at the jail?
Yes, we do.
All right. Could you present that to him, Mr. Bartu, if I could have you read through that form? If you have any questions about it, ask me.
It's straightforward.
Okay. Do you have something to sign it with?
What's today's date?
It's the 3rd, May 3rd.
All right, Mr. Bartu, at any time you would happen to hire an attorney, or if you change your mind and wish to apply for a court-appointed attorney, you can make that request. You'll be expected to abide by all the normal court procedures and rules that an attorney would while representing yourself. I do need to set a bond now. Mr. Canfield, what's state's recommendation for bond?
Your Honor, in keeping with the co-defendant case, the state would request a bond of 10,000 cash surety.
Okay, you're the co-defendant of Savannah Linderman, is that correct?
Yes, sir.
And you also live in Texas?
Yes, sir.
Okay, do you have any ties to Butler County, Kansas?
No, sir.
Okay, I'm going to set bonding the amount of $10,000 cash or surety. All right, I'm now going to address the MR case. All right, this is a fugitive information case, Mr. Bartu. Jack County, Texas is wanting you on a charge of aggravated assault, serious bodily injury. The judge in that case has set a bond of $50,000. So we're not here to address the merits of that case. I'm just need to ascertain if you wish to waive extradition to allow Jack County, Texas to come back and pick you up on this, or if you don't wish to waive extradition, then we'll have to pursue getting the governor's warrant.
Whatever it is where they can come and get me, I'll do that.
Okay, that's waiving extradition, and you'll need to sign a form. Have you all been able to track down those forms yet?
Yes, Your Honor.
Okay. If you could present one of those to Mr. Bartu, same procedure as the waiver of counsel, Mr. Bartu. Read through that. If you have any questions, please ask me. All right, did you read through that and sign it?
Yes, sir.
All right, can you confirm there at the jail that he signed it, please?
He did indeed sign it.
Okay, and you understood its contents and don't have any questions?
Yes, sir.
All right. Texas will probably wait to see what your bond situation is. They may want to wait till your Kansas cases get resolved before they come get you. So I can't tell you for sure when that'll occur. I think it'll depend if you're able to make bond on either one of the cases. So do you have any questions, Mr. Bartu?
No, sir.
All right, Mr. Canfield, anything else on either one of these cases?
No, Your Honor.
All right, Mr. Bartu, you are excused. Thank you.
Thank you.
Are you Savannah Linderman?
Yes, sir.
All right, there are two cases set, both, or the first case is in the matter of Savannah Marie Linderman. That is 24 MR 62. And State of Kansas versus Savannah Marie Linderman. That is 24 CR 213.
I'm sorry, what is that first one?
Or it's State of Kansas. I read that wrong. State of Kansas versus Savannah Marie Linderman, 24 MR 62. What this case is, it's a fugitive information case. Miss Linderman, you're wanted out of
Texas.
Young County, Texas, on a charge of manufacturing controlled substances.
Right. My husband took the charges for those in Texas. Those
Okay.
were his, and he claimed those there. And same with the charges here, with the direct charges. He claimed those as his because they were.
Okay, well, the state of Kansas apparently, or the state of Texas doesn't recognize that that's occurred, as they still have a warrant out for your arrest.
I understand that with Young County. That's how they are.
You'll have to take care of that down there. All we need to accomplish here today is to determine if you're willing to waive extradition and agree to let them come back and get you.
Yeah, I am.
You will waive extradition,
Yeah, that means they can come and get me, correct?
correct?
How many days will that take for them to come get me?
Well, it'll depend. We need to take up the other case too, so I'm not sure.
What other case? The ones that I caught here?
Yeah, I'll go over that here in a minute, but.
Well, then I'm gonna wait to waive anything until I know what these are.
Okay, well, let me go over the other case. Next, this is 24 CR 213. You're here for a first appearance. On this case, there are 6 charges.
6. I was only told of 4. Can I please know what they are?
Yep, I'm gonna go over them with you. All of these are alleged to have occurred on May 1st, 2024 in Butler County, Kansas. Count 1, you're charged with interference with law enforcement. That is a level 9 non-person felony. Count 2, you're charged with theft, a level 9 non-person felony. The allegation is that you were unlawfully obtained or exerted unauthorized control over a white Dodge 1500 with the intent to permanently deprive the owner and Ernest Tescom of the possession or benefit of that property, having a value of at least $1,500 but less than $25,000.
Right. I was told I can make a statement on that.
But let Ms. Linderman, I don't want you to say anything at this point that might incriminate you.
Yes, sir.
I'm going to go over all these charges with you, and then I'll give you some further instructions at that point.
Yes, sir.
Count 3, you're charged with fleeing or attempting to elude an officer while engaged in reckless driving. That is a level 9 person felony. Count 4, you're charged with failure to yield the right of way at a stop sign. That's a traffic infraction. Count 5, you're alleged with failure to signal lane change. That's also a traffic infraction. And in count 6, you're charged with driving 67 in a 35. That's speeding, a traffic infraction. So those are your charges. Since you've been charged with several felonies, you won't be asked to enter a plea today. Your case has been assigned to me, and your next court date will be on my felony preliminary hearing control docket. That will be on June 3rd at 2:30 in the afternoon, and that will be done by Zoom. Can you afford an attorney to represent you on these charges?
No, sir.
Do you wish to apply for a court-appointed attorney?
Yes, sir.
Okay, are you employed?
I am not. I am autistic, and my OBGYN has me where I'm not working at the moment due to I had an infection after my birth, and it's just now recovering.
Okay, how long has it been since you were employed?
Would have been May of last year. I was on bed rest my whole pregnancy. So.
Okay, I'm going to appoint James Watts to represent you. He's an attorney here in El Dorado.
Yes, sir.
They'll be able to give you his contact information.
I'm sorry?
They'll give you his contact information there at the jail.
Yes, sir. If I was, now that this has been discussed, if I was to go ahead and waive to be extradited back to Texas, how long would that take?
Well, before we do that, I need to set a bond in this case.
Okay.
Mr. Canfield, what's your recommendation for bond?
Your Honor, the state is requesting a $5,000 cash surety bond in this case.
Where do you live? Are you from Texas?
Yes, sir.
Okay, what, do you have any ties to Butler County at all?
Yes, sir. My family, my children, my housing, everything is in Texas.
Where in Texas?
Wichita Falls and Jack County. Jacksboro, Texas, and Wichita Falls, Texas. That's Wichita County and Jack County.
I'm gonna set bond at $10,000 cash or surety. All right, let's address,
If I was to sit that out, how long would that be to sit out?
the extradition case.
No, the case here in Kansas.
What do you mean sit it out?
Sit the time out.
I don't understand what that means.
Sorry, I guess I'm just used to Texas. The bond amount is, you put it at 10,000, correct?
10,000 cash or surety, yes.
Okay, I know in Texas we're able to sit that bond amount out. I don't know how y'all do it here.
Well, you can sit in jail or you can pay the,
Right, I don't have any means or capability of paying that bond or
okay.
anybody that can pay it. I don't, like I said, the only person I have in Texas is my kids and my husband who is here.
Okay, well, if you can't make the bond, you'll remain in jail until at least your next court appearance.
Which you said is in June.
June 3rd at 2:30.
Okay. And the you said we're about to discuss.
Extradition case. Let's see if they assigned a bond.
It's 20,000.
And Your Honor, on that, the arrest warrant that we have received, the very first page is signed by a judge of Texas, and it has handwritten on it 50,000. And on the third page, which is not signed by a judge, it has 20,000. The state's position is the one that is judge signed would be the correct bond amount, but I will leave that up to the court.
Okay, and I'm seeing what I have in my file shows $20,000. And it is signed by a judge.
Okay.
Or, yeah. So your bond on the Texas case is 20,000.
Yes, sir.
You can waive extradition. And then they may wait until Kansas is done with you before they come and get you. Or you can bond out on it if you can, and then make arrangements to go back down and get that taken care of. If you don't wish to waive extradition, then the governor of Kansas will confer with the governor of Texas, and they'll
Get a governor's warrant.
right.
I want to go ahead and waive so that they can come get me.
Okay. Do you have a waiver of extradition form there at the jail?
I'm sure we have one here somewhere.
Okay. If you could find that, because I'll need to have her read through that, and I'll need to witness her signature on it if she is wishing to waive extradition.
Yes, sir. Because I have medical things that need taken care of in Texas that Young County can take care of.
Okay. Are you going to need a minute to try to track down one of those forms?
Yes, Your Honor.
Okay. Well, I don't want to hold up a fairly lengthy docket, but maybe once they track that form down, they can bring you back in.
Yes, we can do that.
Okay.
Yes, if you just sit back there. But he might not be done with you yet.
Oh, I'm sorry, Yarna. Were you finished?
Let me make sure, Mr. Canfield, was there anything else we needed to do on the CR case?
Not on the CR case, Your Honor.
And then anything else on the MR case other than the signing the waiver of extradition?
No, Judge.
Okay. All right, Miss Linderman, I'll excuse you for now, but they'll bring you back once you
Yes, sir.
have that form. All right, Miss Linderman, have they presented you with a waiver of extradition form yet?
They are right now.
Okay, go ahead and read through that. If you have any questions, please ask me.
No question. Should I go ahead and sign it?
Yes.
My name on every line?
Not sure what the second line is there. Third line. Let's see, you put the county where it is. So,
Where they're wanting to extradite Young County?
well, is it Young or is it?
It's Young County. His was Jack County. Texas. In Texas 11. Young County. My name again. That's it.
Yeah, one more line there.
Texas.
And then the date. Today's the 3rd of May.
Oh, my bad. Is that wrong?
Just write May in that line there.
This one? Okay.
Thank you.
Thank you.
All right, and can you confirm her signature, please, for the
I
record?
can. Yes,
Okay.
she has signed.
All right, do you have any further questions, Miss Linderman?
No, Your Honor.
All right, thank you. You're excused.
Are you able and free to go for Ms. Willis?
Yes, I am.
Okay. This is 240466 FY, People of the State of Michigan versus Rachel Grace Willis. Appearance for the record.
Good afternoon, Your Honor. Andrew DePaul on behalf of the people.
For the record, Judith Grace on behalf of Ms. Willis. She's participating by Zoom video without an objection for this hearing.
Ms. Willis, good afternoon. Please state your name for the record.
Good afternoon. Praise the Lord. Yes, Mrs. Rachel Grace Willis.
All right, we are here for a probable cause conference. How are we proceeding forward?
Judge, I have had a couple of conversations, at least, with Ms. Willis. I've had one as recent as on yesterday. Judge, at this time, I'm respectfully asking the court to refer this matter to the Forensic Center for Competency and Criminal Responsibility. Ms. Willis indicated to me that she has been hospitalized for mental health issues a number of times. She couldn't give me the exact number, but definitely more than, I believe she said 3 to 5. She was in the conversation, without disclosing any attorney-client privileged information.
Counsel,
she was also had her husband there, and
that is stated in the stand.
Ms. Willis, hold on one second. All right, let Ms. Gracie finish, okay? And I'll let you speak.
Oh,
Go ahead, Ms. Gracie.
We've already finished. As stated in the presence of counsel, I plead the Fifth Amendment right. Ms. Gracie, you are dismissed from your duties. You are dismissed.
Go ahead, Ms. Gracie.
And so, Judge, more of this of what you're hearing right now, not the dismissal part, but just very uncommon, bizarre, to make heads or tails as to what Ms. Willis was saying, and unresponsive to just everyday normal questions, Judge.
I plead the Fifth Amendment right. Attorney Judith Gracie?
Hold on, go ahead, Ms. Grace. I need to hear, this record needs to be clear. Go ahead.
Yeah, yes, and so, Judge, it's just been extremely difficult, as the court is saying, to even get a steady conversation with rational answers. Her husband was there. He was there the first time we had a PCC, and it was put over. And he got on the call at the same time, and just Judge, I've not had that. Yeah, I've not had a situation like this where, again, the answers were not responsive. I'm not sure what's going on with Ms. Willis.
Clear and very responsive to you as our conversation, Attorney Gracie.
Okay, so here's the deal. You're going to be ordered to the Center for Forensic Psychology for Competency and Criminal Responsibility. I'm assigned an order. Ms. Willis, go there. I heard you, Mr. Tabali. Please prep the order. Ms. Willis, please go over there, because I don't want to have them to take you over there. So just go there, get the evaluation, and we'll go from there.
Judge, I think she might be gone. I think she got off the line.
Oh, well.
She hung up on me yesterday and kind of dismissed me and hung up, but I think herself.
Okay, Ms. Gracie, can we come back on June 27th at 10 a.m. for a review? I know
it won't be done, but yeah, I know. Let me just look at that date just to make sure. I'm sorry, you said June 27th?
Yes, and it'll be at 10 a.m. on Zoom.
Okay, that's fine.
Okay.
And I'm sorry, I think, Mr. Tabali, you said that you would prepare the order. She was talking and I couldn't hear you.
Okay, I'll make sure he's get done.
Thank you.
All right, thank you. Are we ready on Mr. Little?
Yes, we are.
Okay. This is 240168 SM, People State of Michigan versus William Cope Little. Here's the record.
Good afternoon, Your Honor. Andrew Tabali on behalf of the people.
And Randall Upshaw, P number 43574 on behalf of Mr. Little.
All right, Mr. Little, good afternoon. State your name for the record. William Little. All right, Mr. Upshaw, I believe you filed a motion for bond in this matter?
Yes.
All right. I think you're asking for a reduction. Because he works in that Gentry roofing. I mean, I read through it. Mr. Tabali, any response?
No, Your Honor, but I can do a oral response. Shouldn't take. Pretty straightforward. The court is aware of what happens. It's pretty fresh.
All right. Yeah. You know, my issue with Mr. Little was the fact that he contacted the complainant or whatever. You know, and then the reason how I know he contacted the complainant after my order, Mr. Upshaw, was because the number he gave the court was the number that showed up on the text message, and I mean on the phone log. I think it was a text message. I remember it was a text message.
It was text message.
Okay, Your Honor, you're aware that I was just recently retained to represent Mr. Little, and I understand what this honorable court is stating, but some of the facts are here. My understanding that the text message, whether it was from his family or himself, it was a non-threatening text message, but I've informed he and his family, even the ones that thought they was very good friends with the victim, there's to be no contact from anyone. Your Honor, he voluntarily appeared. I had the opportunity to brief through the allegations of this incident, and it was an offensive touching by someone throwing some pop or something, but it wasn't a brutal touching. Your Honor, family members as well as individuals make mistakes. Now, she lives in another state, from my understanding. Minnesota, something of that nature, and she was just here visiting. There would be no contact. I've explained to Mr. Little, I've explained to his family, because the victim and Mr. Little's sister and the victim were friends, and I guess somebody passed, whether it's Mr. Little or his sister. I told him it doesn't matter to me. No family, no contact whatsoever, and I think he's learned. He's been in jail. He's on the cusp of losing his job. He works for a roofing company. Judge, I think he's pretty much really learned his lesson on this, Judge. I would think keeping him incarcerated would be extreme with irreparable harm. I think the time that he spent in jail, which has been at least a week or so now, has taught him a real significant lesson, Judge. Based upon these facts, I would ask the court to reconsider taking into effect that he's been in jail. He's learned his lesson. We have talked in detail, and to reinstate the bond, Your Honor.
Mr. Zapata?
Your Honor, here's my concern with this whole thing. Mr. Little was given an opportunity to remain in community while this case went pending, rightfully so, which obviously we did not have an issue. The people did not have an issue at the time being. But if I'm getting emails and phone calls from the victim saying that Mr. Little is constantly contacting the victim in this matter by text messages, by this app that they use, by calling, by texting her, oh, I didn't mean to hurt you. I love you. Please forgive me. I do have a problem with that. The victim has emailed me several times, even though the fact that she's out of state does not negate any of this. Because as we know in the modern world, people can move relatively quick. So whenever the victim is, which I'm not going to disclose her location, it doesn't take long, which clearly Mr. Little knows, and Mr. Upshaw knows, it doesn't take long to jump in a car and a plane to go where the victim is. And there is a reason why this court puts a no-contact order in place, and that reason being is for the protection of everyone, including Mr. Little, so the parties can cool down and things can calm down. Clearly, Mr. Little did not obey to that court order. Clearly, Mr. Little did not know how to take advantage of that because he kept contacting the victim. And the victim kept informing me about, hey, I'm scared of him. I'm scared of him. Please get him out of my back. He keeps texting me. He keeps calling me the random numbers. And if that is all in the conclusion for the victim not to proceed forward with the case. So that is that aspect of it too. Besides that aspect of violating the court's order of no contact. So he's interfering with both of those processes. So I think the bond that the court set in the last contact hearing, it's appropriate, and I would ask this to keep so people can move forward with their case till a bench trial date.
Your Honor, with all respect,
go ahead. I'm done.
All individuals have made mistakes, and over my years, I've seen people contact them, and I take the APA at his word. I have respect for him. I have no problem with that. But sometimes some attorneys don't sit up there and explain the significance of the no contact. No excuse, because I know this judge has. But at the same time, punishment has been given, and I really think he's learned. It's not a forever charge. Judge, if this was a case, and I know all cases are different, if this was a case where he had a real violent history as opposed to wrongfully violating the court's order talking about I love you, it would be different because we'd be afraid that he's the type, he has shot at the staff that did something of that nature. Judge, I think we got to give the person a case-by-case basis because he was foolish and inexperienced enough to send somebody the letters or the text message as stated by the prosecutor. There's no reason to punish him totally as if he was fully guilty and convicted. Judge, I would just take this warning because you have the hammer. If he makes one single phone call, you can max him out and you won't hear any argument from me. But I think we've all seen individuals in a dating relationship wrongfully violate a contact order saying, I love you. And I know that's wrong, and he has been punished for that. But based upon these facts, Judge, I think at this time, he deserves a second chance.
So, Mr. Polly, has she reached out to you saying she's been contacted since he's been in custody?
No, Your Honor, since the custody, we haven't had any issues.
And that's my issue. So like, if it was him going somewhere and bothering someone, then I could put him on a GPS tether or home confinement. Or I could put him on GPS tether and have a bubble zone around a person's place of schooling and working and all that stuff. But this is phones. And I know in the jail he can't contact her. But if I let him out, put him on tether and tell him to go to work, don't even leave this county without my permission, I can't stop him from texting or calling. And then the fact that there has not been any calls or texting since he's been in jail, that's indicia of contact. So, and then my orders have to have bite.
I understand, Judge.
That I don't sit on this bench for fun and I don't talk for fun. I've been empowered to skillfully and rightfully administer justice. And so, Mr. Little had an opportunity, like I let him out. He had a $2,500 personal bond from Judge Walker. And then for some reason, the complainant didn't appear at the final pretrial or something had occurred. But there was a lot of allegations of contacting when she needed to appear for the final pretrial, because I do final pretrials and make sure these cases actually go forward. She didn't appear, but it was learned that he was contacting her, influencing her. I love you, all that stuff. So, I just don't feel comfortable with him being out. Like I said, if it was him going somewhere, I could put a tether on and say, don't go nowhere.
But Judge.
Well, this is Texas. And then I want to say this as well. Mr. Little, when you get on the phone and talk to your family, anybody who contacts her and bother her, there will be charges pressed against them for intimidating a witness. No, do you hear what I'm saying? Do you hear what I'm saying? Do you comprehend what I'm saying? If anyone who is an agent of yours, a friend, a family, an associate, a comrade, a gym workout partner, a golf buddy, reaches out to this complainant by phone, social media, bat signal, FedEx, they're gonna get in trouble, and then I'm gonna bring the hammer down on you too. Leave this young lady alone, because let me tell you something. You're not talking to a dummy here. Mr. Upshaw will tell you that I practice domestic violence. I done seen it all. I know the trick of the trade. I know which way people try to influence victims or complainants not to come to court. I've seen it. I've even had idiots in the jail call, knowing all calls are monitored and recorded. So, I just don't feel comfortable. I don't. I'm sorry, Mr. Upshaw. I respect you, Mr. Upshaw. You're one of the finest attorneys, and I don't give that title to many attorneys. But I just think Mr. Little can't control himself, and I don't think you can control him. As much as you tell him he shouldn't contact, he gonna contact. The fact that there has not been contact while he's sitting in jail is indicative of that he's been contacted in violation to get her not to come to court. So I've made my decision. Bond, motion is denied. I will see him on the jury trial on May 15th. No, it's been vacated, so
can we just change that? Can we change the pretrial to a trial date?
Please. We need to set another trial date.
Yeah, I don't think we have a trial date in place. Are we doing bench wait jury, right? Are we doing
jury? Hold on, let me back up. We set a final pretrial date for May 21st at 9:30 a.m. on Zoom.
Correct.
If we set a trial date, it will most likely be in June.
Can I please speak to Mr. Upshaw? Yes, sir.
I know I'm assuming. I apologize, Your Honor.
Very fine.
While it's early on, my client has raised concerns about when his prior court-appointed attorney waived his right. And at this point, Your Honor, he was wishing that the court would set a jury trial as opposed to a bench trial.
No, it was always a jury trial.
Okay, so it's, I heard Mr. Topoli's say, I thought he said a bench trial. If it's a jury trial.
I didn't recall whether we did one or another. I was asked.
Okay.
Yeah, it was
Nothing
always
further,
a bench trial. We have a final pretrial on May 21st.
Can I speak to Mr. Upshaw in private, please, sir?
Is that in the AM or PM on May 21st, Your Honor?
9:30 a.m.
Yeah, they can.
Oh, yes. Okay, I got that there. Is that gonna be on Zoom also?
Yes.
Hey, can we have a breakout room, Your Honor?
Yes. You go back on the record with William Little. Case number 240-168 SM, People, State of Michigan versus William Cope Little. Appearance for the record.
Enter to file on behalf of the people, Your Honor.
Randall Upshaw on behalf of Mr. Little. Mr. Little, state your name.
State your name for the record.
William Little.
So, Mr. Upshaw, I believe you said there was a resolution in this matter?
Yes, Your Honor. My client is willing to enter a plea of guilty. I have no, I believe there's a recommendation from Mr. Topoli. I didn't explain this, so I apologize this, and I would ask the APA if it's agreeable with the victim, would they consider the 769 or the 771, whichever one it is? And I'm seeing him shake his head no. So at that point, my client, Mr. William Little, are you willing to enter a plea of guilty, knowing you're giving up your right to trial?
Yes, sir.
Your Honor, I would ask the prosecutor to put his recommendation on, and we think we can resolve this matter.
Your Honor, it is my understanding after speaking with Mr. Upshaw that if he pleads today, I would not have an objection to a personal bond. As at this point, the plea would be out of the way. It would be no interference with the case. I know the victim is somewhere outside of the state. I don't want to disclose that on the record, but it would not be an interference. And I would ask the court, we set this for sentencing after we take in a plea. So we're giving opportunity to the victim to address the court under the statute.
Court, raise your right hand. Mr. Little, I'm sorry, Mr. William Little, raise your right hand. Do you swear or affirm subject to the pains and penalties of perjury, your testimony you give this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, you may put your right hand down. You have a right to a trial by jury in this matter. Do you understand?
Yes, sir.
The jury be composed of 7 residents who reside here in the city of Pontiac, randomly selected by your attorney and a prosecutor in a process we call wide jury selection. Do you understand?
Yes, sir.
At the end of that process, the prosecution is required to put on evidence before those 7 jurors that you're guilty beyond a reasonable doubt of domestic violence. Do you understand?
Yes, sir.
And you have a right to remain silent at trial, meaning you don't have to testify and or present a defense, and your silence cannot be used as guilty against you. Do you understand?
Yes, sir.
In the same breath, you may waive that right to remain silent and testify and or present a defense, but you're not required to do so, and no one can force you to do so. Do you understand?
Yes, sir.
And at the end of the trial, 1 juror will be dismissed, 6 are going to deliberate. Those 6 jurors must all agree that you're either guilty or not guilty of domestic violence. They must return a unanimous verdict. Do you understand?
Yes, sir.
They can't reach a unanimous verdict. It'll be declared a mistrial, at which time the prosecution can try the case not at a later date. Do you understand?
Yes, sir.
You have a right to see, hear, and question all witnesses in open court against you. Do you understand?
Yes, sir.
If you have witnesses that you want to come testify on your behalf in your defense, the court will issue subpoenas to order those witnesses to trial. You understand?
Yes, sir.
Those 5th Amendment rights to remain silent at trial. You understand those rights?
Yes, sir.
Any questions about those rights?
Sir.
Was that a yes or no?
Yes, sir. Could you close the door? I can't hear you. Thank you, sir. I couldn't hear you because they got the door open and it's loud outside. Yes, sir. I understood what you said.
I said those 5th Amendment rights. I wonder if you have any questions about those rights?
No, sir.
You understand those rights?
Yes, sir.
All right, and as you sit here now, you're presumed innocent until proven guilty beyond a reasonable doubt. Do you understand?
Yes, sir.
All right, so you want to plea as charged in this matter. Is anyone threatening you, promising you anything, or forcing you to waive your right to go to trial?
No, sir.
Are you currently on probation or parole anywhere?
No, sir.
And you are a citizen of the United States of America?
Yes, sir.
Do you enter in this guilty plea knowingly, intelligently, and voluntarily? Do you understand the consequences of what you're doing?
Yes, sir.
Mr. Upshaw, Mr. Topali, a factual basis for the plea?
Go ahead, Mr. Upshaw.
Okay. Mr. Williams, Little, on January the 13th, 2024, were you in the city of Pontiac?
Yes, sir.
Were you in the company of a person by the name of Shelby Clapprick?
Yes, sir.
And at that time, did you make an unconsented offensive touching of her body?
Yes, sir.
Without her permission? She didn't give you permission to perform that offensive touching, is that correct?
Could you explain the offensive touching as far as?
She didn't give you permission to offensively touch her, whether it was pop, water, or whatever, correct?
Yes, sir. No, sir. No, sir.
Your Honor, we're satisfied, I believe.
I would follow up with one more question. What did you do you believe was wrong against Ms. Calvich? And she didn't give you permission.
What did you do? Did you throw a pop at her, some pop on her?
Yes, sir.
All right, people satisfied. Thank you.
Defense is satisfied.
The court is satisfied the factual basis of the plea was entered into knowingly, intelligently, and voluntarily by Mr. Little. He understood the consequences of doing so. Is not disclosed anyone on record threatening him, promising enforcement of his right to go to trial. So we enter a guilty plea as charged. I'll set this out 30 days for sentencing. I'm just gonna be 100% honest with you. You know, pretrial release gives me paints a picture to me of how a person's gonna be on probation. So I'm not interested in probation, to be honest with you. So I'm gonna give 30 days and I'm gonna ruminate over that. And my mindset may change, but the evidence I have of him, how he's gonna act on probation is how he acted on pretrial release. So we'll come back in 30 days. It'll be on Zoom. Mr. Upshaw, is your May 30th okay?
Say that again, Judge.
May 30th, is that okay? That'll be at 9:30
Yes, it is, Your
on
Honor.
Zoom. Okay. So it'll be at 9:30 on Zoom. Mr. Topali, if you want the complainant, now the victim, to speak, please have her present herself on Zoom. She doesn't have to come in and we can go from there.
Sounds good, Your Honor. Just for the record, we're canceling the jury trial date and everything else. I'm canceling all my witnesses since we have a plea.
And Your Honor, regarding his bond, is his bond reinstated?
I'm having a hard time reinstating this bond.
Judge, with all respect, every reason
No, it's a problem.
that was given for him to interfere is now gone. It was never a violent beating. He threw pop on her. They had an argument, he threw some pop on her. Judge, with all respect, he knows better to do anything wrong. Any incentive for him to act up, his history didn't include him beating on her or physically harming her besides throwing pop on her when they had an argument.
Okay. This is what I'll do. I'll let him out on personal bond, but Mr. Little, if you have one contact with her, it's 93 days Oakland County Jail. Do you understand me? That'll be a sentence. One contact from her, one. If Mr. Topali brings me one allegation, 93 days Oakland County Jail. Ball is in your court. And that's for anybody around and connected to you.
Yes, sir.
Understood?
Yes, sir.
All right, thank you.
And thank you, Your Honor.
Your Honor.
Hey. Chapa. Jessica Chapa. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail or $2,000 fine. What are we doing, Matt? Are we doing time served?
Yes, sir.
They've offered you 3 days in jail, give you credit for the 1 day that you've done.
I was gonna say, Judge, just for your knowledge, I guess a week after this case happened, I was assigned to it. Ms. Chapa checked herself into inpatient treatment where she was away from everybody for about a month, so.
Is this what you want to do?
And we did attempt, or I did explain a PTI, letters were generated, and after some more conversation, she indicated to me that this is the route she wanted to take.
Sure, because the problem is, Ms. Chapa, once you plead guilty to something, you can never change your mind. This isn't like Target where I don't like the result, I'm just gonna go refund it. You can't. Once you plead, you're stuck with this for the rest of your life. From now on, you will be facing a minimum of 30 days in jail. If you ever pick up another DWI, you're facing a year. Your insurance is gonna skyrocket. I'm gonna suspend your license. So the other avenue, like Matt was telling you, is they have an intervention program where if you successfully complete it, they dismiss your case. But you have to apply. Once you get in, you'll have to fulfill a couple classes, a little bit of community service. And if you do that and you stay clean, the case gets dismissed. Is this what you want to do?
Yes.
You're old enough to, I mean, you're in the driver's seat. You're the one that makes a decision. No one else is going to. So, okay. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So like I said, once you plead, that's it. You're stuck with this forever. Now, like I also told you earlier, this is going on your record. If you ever get pulled over, an officer's going to see this DWI. If they smell alcohol on you, you think they're going to be nice to you? I don't think you understand. If you get pulled over, an officer will see that you have a prior DWI. If they smell alcohol on you, what do you think they're going to do to you?
Give me the jail or give me the worst, third degree search.
They're just going to take you to jail and they will charge you with a second offense. That's what I'm trying to impart to you, is that you should never get in a car, even if you've had one beer, because it doesn't matter. They're going to see your prior DWI. They're going to assume that you're drunk and they will take you in. What we're doing today will not happen again. From now on, it's a minimum of 30 days in jail. Do you understand? How do you plead to the offense, man? I will find you guilty. I will follow the agreement. I'm going to suspend your license for 90 days, ma'am. Do not drive until you get a license, and good luck to you. Thanks. Hey, Connor.
Hey, Judge.
What's up, man?
Judge, I'm approaching on a case that's set for tomorrow. The case number is 247-9751.
247-9751.
It's Chelsea Rogers.
Okay.
She's set for bond forfeiture tomorrow, Judge. She did have a medical emergency last week. She is here right now and is going out of town tomorrow. So I was just going to see if we could address that today and then possibly get a reset. Right now.
So it's 5 months old.
Yes, so there is a decision-making class in 16 hours community service PTI on there.
When was it offered?
It was offered a while back and then it was modified at the beginning of April 4th, I believe.
April 3rd.
April 3rd.
What happened?
Judge, so the current offer is EDM and 16 hours community service. The original one, I had an extra class, I just took the class off.
He took a class off and she still can't get it done. And when did you offer it?
The original was offered, Your Honor, February 7th, and then I modified it April 3rd.
Come up, Miss Rogers.
Obi?
I'm not very happy with you, Miss Rogers. I don't know if you're not taking this seriously. Oh, he's in. But you've now been given over 2 months to complete 1 class and 16 hours of community service to get this case dismissed.
I'm not trying to go against you, but I have the text when he did offer it, and it was like a week or 2 ago. Can I check the dates on the thing? Because I wasn't aware it cost 50 for each class, and it's 2, so that's 100.
You have 1 class to do and 16 hours of community service. The
Okay.
class was offered in February, or the offer was given to you in February. Did you extend the offer to her in February?
I would have to check my text messages, Judge, but I don't, it was at least a month ago.
Be that as it may, your case is nearing 6 months old. I will give you 1 final reset to get this done. Ms. Rogers, if you don't have it done by the next time you come back, I will set your case for trial. All deals are off. Do you understand? So it's now 4:30. How long will it take you to get 1 class and 16 hours of community service done?
I get back on the 8th, so after that I can pay for the classes, and then I have one place that I was looking into. It's kind of like a ranch for the community service. It's like a ranch. You just help them out. And
You can go to a local church. You can go to the Houston Food Bank. You can go to Bark. You can go to the Houston Area Women's Center. You can go to, what's the animal place?
You mentioned Bark.
No, there's another one.
Humane
The
Society.
Houston Humane Society.
And that-
Most of these people will let you go like this to go work so that there's no excuse. Don't bring something on a bar napkin because it's not going to work. It must be on legitimate letterhead. I will give you a final 30 days. There's no excuse. You will not get any more resets after this time. Okay, thanks.
47590.
I thought I had revoked the bond, did I not?
You revoked them, I think yesterday you moved out to here. And then you're just putting them back.
But it's showing bond active. I thought.
Oh, yes.
Oh, you just reinstated? Okay. If you ever fail to appear again, I'm going to make your bond a very, very high. You will never get another get out of jail free card. Do you understand, Mr. Rodriguez? Never. You don't come when you want to come. You come when you're ordered to come. I'm sending you now to go get your TRAS done for your intervention program. You will only get a 2-week setting. You must have everything done within the next 2 weeks. Otherwise, I will set you for trial. Do you understand? Okay, so he's pleading to a DWI second thing. Okay. Mr. Menchu, you're charged with driving while intoxicated, second offense. This is a Class A misdemeanor. You're facing up to a year in jail and or a $4,000 fine. Now, if I remember correctly, as part of this DWI, someone was actually killed. But the problem was causation. So we couldn't prove that it was the actual DWI that caused the death versus perhaps an intervening, superseding event that actually caused it.
Correct.
Okay. Mr. Menchu, the fact still remains that someone is dead. We lead the nation per capita. In every single other state, we lead the nation in people who die due to an alcohol-related collision. You are now one of those statistics. How is it fair that this person is not now alive, but you are? How is that fair? Why is that fair? Understand that this is now a second. If you ever have alcohol on your breath, in your system, and you get into a car and you're pulled over, you will be facing a felony charge, up to 10 years in prison. And I will tell you now that if you pick up a felony DWI, the DA's office is going to be all over you in punishment to try to max you out to 10 years in prison, because they will bring this up and use this against you. You understand? So if you are not smart enough to consider how to get home other than getting in a car after drinking, you will be doing a lot of time in prison, and rightfully so, because what the hell is it going to take for you to get into your thick skull that you shouldn't get into a car after drinking? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. What are we doing in this?
Some probation judge with 10 days as a condition.
Fantastic. I'm happy that you're getting on probation, because I'm going to keep you myself. I'm not letting you go anywhere into the region. I will supervise you myself. The first time you consume alcohol, if you do, I'm going to put you into a rehab facility. I promise you. I don't care if it's mouthwash. I don't care what it is, a hair dye, whatever excuse you may be. You will go into a rehab program. It's 10 days in jail to do as a condition, meaning you will do every day of 10 days. It is 1 year in jail, probate for 2. You will do a repeat offender DWI education class. What else?
I wasn't sure if this court has it under probation. I've seen some that they do a DWI caseload to keep a closer eye on these kind of cases.
Oh, you mean sober court?
If sober court, if you think sober court's fair.
I don't know, because let's do this. Let's do a TRAS, and then let's see what the TRAS does, and then we'll do what they recommend. If they think that he should do sober court, then so be it. If not, then he'll stay with me and I'll supervise it myself.
Yes, Judge.
So you will be doing what a TRAS, which is an evaluation to see what conditions, other conditions you may need. You must fulfill those conditions. If they say you need sober court, then you must do sober court. No drugs, alcohol, random urinalysis. You will do, did you have a victim impact panel?
Yes, we had 3 victim impact panels on this one, Judge.
You will do 3 victim impact panels. You will no breath test refusal, meaning that if you were pulled over in a car, which you shouldn't be because I'm going to suspend your license, but if you are unwise enough to get into a car and drive and an officer asks you to submit to a breath specimen, you must take it. I am going to suspend your license for 2 years. Don't you get into a car. The worst thing that you could possibly do, if you want me to sprout horns in a tail and become the devil, get into a car and drive. 2-year driver license suspension.
Just for the record, he does not have a license.
Don't drive. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, Mr. Menchu, there's no more turning around. You can never challenge this or change this. You cannot say, oh, I didn't know what was going to happen with immigration. You were done today. You were done forever. Do you understand?
Yes.
Is this what you want to do? How do you plead to the offense, or guilty or not guilty? I will find you guilty. I will send it you to the agreement. Please see the clerk.
Thank you, Judge.
Thanks, Joe.
I filed the dismissal.
Okay, thanks. Oh, Joe, yeah. What, 10 days? When are we doing?
Can you go in Friday, Judge?
Sure.
Thank you, Judge.
Thank you, Judge. May I be excused?
Thank you.
Thank you.
Mr. Slager, who do we have?
Yes, Your Honor. Mr. Santiago.
Good morning, Mr. Santiago. All right, so you are charged with threatening the exhibition or use of a firearm at school. You're facing up to a year in jail and or a $4,000 fine. Looks like you guys have worked out.
Yes, Your Honor.
What are we doing?
I think he's gonna do an 18-month deferred adjudication.
Okay. Do you know what that is?
Sir, Your Honor.
A deferred adjudication is a type of probation that if you successfully complete, you do not end up with a conviction, but it's not dismissed. So you cannot tell people it was dismissed. You did the probation. If you successfully complete it, you don't end up with a conviction. This is important because this type of case, if you end up with this type of conviction, it's going to haunt you for the rest of your life. It will be very, very difficult for you to get a job. What are you, 17, 18?
18, Your Honor.
18, I'm telling you. This could really, really hinder your even ability to just get a job at Burger King. What do you do now? Where do you go to school?
Sam Houston High School.
So you're a senior or are you a junior?
Currently I am sophomore. I'm supposed to be a senior.
You're supposed to be a senior. It doesn't matter. All you got to do is get through the finish line. You have to finish school. And this is wonderful because we have him for 18 months. I can make sure you graduate because you need at least 2 more years. And I'm going to keep you under my thumb to make sure that you graduate. And if I have to put you in jail because you start acting like a fool, I'll do it in a heartbeat. Mr. Santiago, my main concern are 2 things. No dope, no weapons, well, 3 things, and graduate from high school. If you can do that, I will be a very happy person. And if I'm happy, you think you're going to be happy?
So you're
right. If I'm upset, what's going to happen to you? I'm not asking for much. All I want you to do is stay clean, get your classes done. I will pay for everything for you too. Other than, is there a class outside or what are we doing?
Effective decision making is the class I've seen.
Okay, which one, Pavel?
It's the online effective decision-making class.
He's probably already done. We supplied a mitigation package, so he's probably already done it, but I'll.
What say you? Are you happy with that?
Judge, let me see.
So what you have to do is you have to do an effective decision-making class. You have to do a gun safety course. You will do what's called a TRAS. That's an evaluation to see what other conditions you may need. You must fulfill those conditions. No drugs, no alcohol, 24 hours of community service. As long as you're in school, I'll kill the community service. And I will make you a deal. The minute you finish high school, if you do well, I'll take you off probation. If you finish high school early, because you're able to do that, I'll take you off. No drugs, no weapons. Val, what say you?
I'm looking at the PTI right now, the PTI package submitted. Yeah, he needs to do the class. Effective decision making class. Okay.
So I will pay for everything for you. The only thing that you're going to have to pay for is the gun safety class and the effective decision-making class. It's not expensive. It's probably $30 each. Okay. Is there a way that the MAC, do you have, you know how the DA's office has classes online, don't they?
Yes.
Do they have these classes?
So the DA's office, the classes that we accept, the ones that we get notified when they're completed, they're about $50 each. I know some defendants have been looking for alternative options. We're not accepting those for deferred anymore because we don't have any way of knowing the certification or what.
The MAC does have a program, which they gave me the information today for those classes.
Okay. So Mr. Slager's going to help you to see what they can do about covering the class for you.
This was one of my last two retained cases. This wasn't a MAC case.
Oh, it's you're retained. Oh, got it. Okay, we'll still try. You know,
It's an open website, so it doesn't matter if you're MAC or not. They just gave us an alternative to use. I think the DA's classes went up to $50. They found organization that does them for half that price. And we've been using it for since they sent the email out, so we don't think it's going to be a problem with acceptance.
I'm happy if you don't have any weapons, no drugs, no alcohol, and you graduate. The most important thing is you graduate. Do you understand?
Yes, sir.
If you ever have a problem, come back and we can talk. But if you take off, all bets off, you're going to be doing a lot of time in jail. If you violate this probation by picking up a new case or doing something wrong, I will issue a warrant. I'm going to put you in jail. The only thing we're going to talk about is if you violated your probation, you give me the authority to put you in jail for an entire year. You understand? Can you get this done? The minute you graduate from high school, I'll take you off. How do you plead to the offense, Mr. Santiago? I will not find you guilty. I will work for 18 months. Make us proud. Good luck, guys. Thanks.
Thank you, Your Honor.
Thank you, Mr. Santiago.
Thank you guys all so very much for watching, and I'll see you next time.